I mispronounce your name every time, sir. It's okay. I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
All right, guys, buckle up. Today we're diving into a courtroom drama that starts with tension. The judge calls the case, the public defender steps forward, and Mr. Johnson is asked to state his name. It seems routine, but in just seconds, we learn the hearing is about a bond violation. That seed of suspense is planted early as we sense something serious is coming.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably has indicated that he had old duels. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul.
In this section, Mr. Johnson admits he violated his bond by consuming alcohol. The judge acknowledges the plea but immediately probes the truth. Johnson had said he only drank odorless non-alcoholic beer. Now, under pressure, the judge asks if that's really the whole story. Tension rises as the courtroom braces for a revealing moment of truth.
Yeah, I don't look like what I'm going through.
No. Hey,
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got
the
you.
story.
Here Johnson finally admits he also drank real beer. The atmosphere shifts. What began as a small offense is now exposed as deception. He claims he just omitted the beer because he was afraid of the consequences. The judge doesn't buy it. His tone becomes sharp, showing that honesty in court isn't optional, it's mandatory. Suspense builds as credibility erodes.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at.
The judge confronts Johnson with blunt logic. To reach his BAC, he'd need 25 bottles of odorless and never use the bathroom, an absurdity. He harshly labels the lie stupid, emphasizing that this wasn't a harmless omission but a planned deceit. The courtroom tension spikes as sincerity clashes with manipulation. Johnson is cornered, and the stakes grow higher.
You would have had to have 25 O'Doul's in an hour.
No, I didn't have
in
that.
order to reach that level.
Sure.
And could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
In regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I
Well,
understand.
I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation.
The public defender asks for leniency, emphasizing this is Johnson's first bond violation. She argues he's a family man, business owner, and active volunteer. She hints he's ready for treatment, requesting the judge let him stay out under strict monitoring. This moment marks a turning point, offense being reframed as opportunity, if only the judge can be convinced.
Here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he's asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions.
Now the prosecutor steps in, challenging the notion of leniency. This is Johnson's second offense, they remind the court, and at his arrest he had firearms. They argue that his past conduct raises doubts about whether he can comply now. This creates a powerful clash, defense's hope for rehabilitation versus prosecution's insistence on caution. Courtroom tension sharpens.
As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
The judge, not convinced by the defense, revokes Johnson's bond temporarily. He criticizes the lack of honesty and commitment to the court's process. The exchange underscores that apologies mean little if not backed up by truth and action. Johnson's situation goes from dim to dire as the courtroom braces for the next twist, a new bond hearing with higher stakes.
Can I address bond, Your Honor?
Well, what are we going to be doing on the case first?
I got your green sheet. I forgot to give it to you.
All right. You're asking for an adjournment of the proper
Yeah.
cause.
Yes, Your Honor.
I'll give you a date and moment depending on the outcome of your bond motion. Go ahead.
Your Honor, I've provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today along with
I do see you.
my client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But
Wow.
and I'm not
At the new bond hearing, Johnson brings community support, his pastor and family. The defense highlights his role as a caregiver, chef, and volunteer. They paint a picture of someone rooted in community, trying to turn a page. It's a last-ditch effort for redemption. The court listens, but past lies linger like shadows, threatening to eclipse this act of hope.
Not candid would be an understatement. I mean, he just outright lied.
Well, I wasn't there.
That makes it no less a lie.
I'm asking if you want to hear from him.
I'll-
A humble apology.
I will certainly hear from him, but not if he's gonna sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize.
Johnson takes the stand, humbly apologizing and admitting he panicked under stress from funeral arrangements. He confesses he drank more than initially stated, aiming to be more forthcoming this time. The courtroom leans in. This emotional moment shows vulnerability, not courage, once again requesting forgiveness from a system that demands accountability first.
For our last encounter.
You consumed alcohol and when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it's too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you drink?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so
So
did you have any O'Douls
at first, but
at first? Okay. How many O'Douls did you have?
6.
6. And then you had how many?
Labatt's about 4.
4.
Sure.
Okay, now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen.
The judge methodically unpacks Johnson's shifting story, 6 O'Douls, 4 beers, then backtracking again. Each inconsistency chips away at his credibility. This meticulous unraveling is both tense and telling. The court watches as Johnson attempts to stay above water, but his credibility is sinking fast. It's a pivotal moment of reckoning.
You were trying to tell me what?
Nothing. That's what I
No,
told you.
no. Let me tell you what you said, because I remember it very clearly. You told me that you had 6 O'Douls. I told you to get to the levels that you were, if you were just drinking O'Douls, because you were insistent on that, you would have had to have a little over a case of O'Douls. Remember that?
Yes.
Then, at that point, you realized, well, he looks stupid, but he's not. And then you started telling me that you had 2 beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. Remember that?
Treatment.
Now the judge presses Johnson over claims of being in treatment. Johnson admits he wasn't enrolled, only seeking help. The judge calls this misleading. This isn't just about drinking, It's about presenting himself truthfully to earn a second chance. Each layer of deception deepens the court's skepticism.
He's trying to go to treatment.
Well, okay. Yes.
I'm just trying to.
I don't understand the question.
You said it to me.
He said at the
Did
last,
you or did you not tell me that you were
I wasn't
in
there.
treatment or had started treatment?
We're looking for a place to go to treatment. That's where we're starting, we're trying to go. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
Already done.
So see, okay. And I know you know this, but I'm just going to remind you. That's what happens when you lie.
And I apologize.
I know a whole lot more than it appears that I know. And the moment you told the people at Community Corrections about O'Doul's, I knew you were lying. That was my first start. Now, if you can
Apologizes again, but the judge reminds him that lies have consequences. He explains how that first falsehood triggered the whole cascade of doubt and detention. Johnson's emotional moment clashes with courtroom procedure, a clash of remorse and accountability. This is the crossroads, tearful apology versus practical consequence.
tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom. Because that's the only way that was going to happen with those duels.
That didn't happen.
Yeah, so that's was kind of the stupidity of the lie. And then it just got worse for me. And then as it got worse, then you ended up going to jail.
I get it. Oh, I get it.
So how are you going to get in? You have insurance to cover treatment.
We're working on that. We just changed insurance, so it's not clear about.
his family's here, Your Honor.
They're
Oh, I
working it
know
out.
they're here, but you told me, Mr. Brown, at the bench that he's got insurance that will cover his insurance.
They're-
And I'm just asking, will his insurance cover treatment?
We're working on that now to get a definite. Yes, it will cover some sort of treatment. Yeah.
Defense counsel shifts focus to logistics, verifying insurance to cover treatment. The court needs proof that help is real, not just promised. Johnson's future depends not on words, but on timely action. The prosecutor nods. It's not that they don't want him helped, they just need assurances it will happen fast and fully documented.
Anything from the people?
Your Honor, people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person at no point. And we allege that, we're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor. And we think about treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment, so we do have some concern there.
Anything else, Mr. Brown?
No, Your Honor.
The prosecution reiterates concern, Johnson's past, his incomplete understanding of the problem, the seriousness of alcohol misuse. They affirm the defense's claims about character, but warn again that good intentions aren't enough. This is a reality check. Redemption requires follow-through, not just sentiment.
Johnson, here's what I'm going to do. I'm going to first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a scram tether because you were on a sober.
Correct.
You're going to go on a scram tether, so I'm going to monitor you 24/7 for any alcohol consumption. I'm also going to order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that and the prosecutor's office that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm going to issue a warrant and I'm going to have him picked up.
Understood.
You understand all of that, sir?
I do.
Thank you.
Thank you, Your Honor.
No, just, we'll do that. Okay.
The judge makes his final ruling. Bond is set at $25,000. Johnson must wear a scram tether and enroll in treatment within 10 days or face a warrant. No more leniency. The system still offers a path forward, but only if Johnson abides by the rules. If you found this breakdown insightful, like the video, subscribe to the channel, and we'll see you in the next one.